Emina 36 na Legislature in Guam is back in session. We're on the second reading. We left off yesterday on an amendment by Senator Taitagui. It is AB 108-TTT, line 13, page 3. And we left off, Senator Brown had just finished speaking on the amendment. Is there anyone else who would like to be recognized on the amendment?
On the Taitagui Amendment, Speaker Terlahi, you are recognized. Speaker Therese Terlahi, you may proceed. Good morning.
Good morning. Thank you. So the amendment before us is, we're talking about the Adoption Review Committee, or the Adoption Selection Committee. This is the committee that gets together and tries to match these children with prospective adoptive parents. And the amendment before us, so the bill would have exempted newborn infants relinquished under the Newborn Infant Safe Haven Act. So this bill would exempt those newborn infants from needing, or from there being a meeting to address those newborn infants by this adoption screening committee. I think the current setup for the committee allows that, this committee to be screening adoptive parents in advance, and allows for them to maybe even make a waiting list, but to definitely screen in advance and kind of pre-select adoptive parents. But one of the things that the committee is supposed to do is to ensure that the children who are up for adoption, to ensure whether they have special needs, to ensure what is in their best interest, to ensure that the capabilities of the potential parents meet these needs of that particular child. They match the children with prospective adoptive parents. And they have criteria as to how they're supposed to be making these decisions. I'm looking on page 4 of the bill on subsection F, and these parts were not amended. And some of the criteria is that, if at all possible, the child will be matched with characteristics of the potential adoptive parents, among others, ethnicity, physical characteristics, and others, to increase the chances of the child fitting in with the family. This committee is also supposed to ensure that children with special needs may have other criteria that the adoptive parents might need to match. For example, if there is a disability, that the adoptive parents will be able to address and take care of the special needs because of that disability. There's also a subsection here that says, for all Native American Indian children, efforts must be made to place these children with American Indian families in accordance with the Indian Child Welfare Act of 1978. This is a federal statute. And they're supposed to be doing this all on a case-by-case basis. And so my only concern with the bill as proffered in creating an exemption for those children, newborn children, who are relinquished under the Safe Haven Act is we do not want to bypass this criteria. I don't think we want to bypass the selection committee's screening of the adoptive parents. And so I think, I support the amendment in that it will remove this exemption. But I think that there is a harmony of interests in, removing this exemption and allowing the intent of the bill, and that is that we can plan ahead for babies, for newborns that might be relinquished according to the Safe Haven Act. Right now, the Safe Haven law requires that they be screened for medical concerns. That's the first thing that happens with the babies relinquished under the Safe Haven Act, that they're going to be screened for any type of medical concern. And I'm sure the theory is that so those can be addressed immediately, and those can also be addressed going forward. And so I don't think there's anything currently to prevent the screening committee from pre-screening adoptive parents, pre-selecting adoptive parents, either for newborn babies, and just ensuring, or even planning for potentials, such as, race, or ethnicity, as the statute calls for, such as characteristics. I don't know what other special characteristics, but I'll leave that to them. And then, of course, just the ability to deal with certain different types of disabilities. So the amendment, again, just proposes to remove this exemption, to continue to allow the screening committee to make these determinations that match that child, that particular child. And I think they can make many of the determinations in advance, but there may be some that they just cannot make in advance until they see the exact needs of the particular child. And if we bypass this screening of the particular needs of that particular child, it looks to me like we are bypassing the whole intent of the underlying law, which is to make sure that it's the best interest of this particular child that's being addressed. And so if they can address all these matters in advance, that's great, but I think we don't need to preclude them from having a meeting. They can make a summary meeting to make these types of determinations once they see the particular child that is in front of them. And I just think they need to be briefed. The screening committee should be briefed on what medical findings there were after the child was placed in their medical care. So again, I would support the amendment to remove an exemption and to continue to allow the screening committee to screen adoptive parents in advance, but to allow the screening committee to see the particular needs of the child as mandated by statute before they make a final determination that this particular child's needs are going to be met. And that's all. And I think, again, that these two principles can live in harmony by removing this exemption that's proposed in the bill and just continuing to allow the scrutiny of this committee for every particular child's needs. I don't think we should, ignore the criteria that has been laid out for CPS right now in determining placements. And I don't know if, when I read this, when I read that one subsection F, in subsection F, that talks about Native American children, efforts must be made to place these children of American Indian families. It just reminded me, and it's actually been in the news recently, of like this was a different era when it was policy to take children away from Native American families, place them, to try to do all kinds of things with them to change their characteristics, I think. But anyways, I think it's very clear, and I don't think there's anyone of us in here who wants to go back to those days when we are not trying to do what public health was intended to do, and that is, first of all, to keep families intact, if at all possible. Second of all, to address the needs of the babies first, and not to go, depart from. I don't want to become a, adoption haven here on Guam, where Chamorro babies are, being put up for adoption and taken off island. I don't want to see that. I think the people of Guam are very willing to adopt babies, and if I dare say, newborn babies are in the highest demand for adoptions. That's the ideal baby that people would want to adopt. Those should be easier to adopt. I think those with disabilities, then the pool may become smaller. But I still think that the people of Guam have been very willing to adopt these babies, and I just would like to see, I don't want to see any departure from these policies that have been set. I don't want to be reminded of the days of, I think New Zealand and Australia, they're talking about babies, again, who were taken from parents and raised in a whole different culture. And I don't want to see that either. So I like the criteria. I'm glad that we're keeping it in place. I don't see any harm in allowing the committee to continue to vet the individual needs of the child, and they can't do that necessarily in advance without the babies being born and being assessed for medical conditions. And really, that's all there is to it. And I agree with the sponsor of the bill that they should do this promptly if there's a baby that's been relinquished under the safe haven law. And I think that they can do that promptly. There's been no evidence to show that they cannot act promptly in determining the medical needs of the child or the best interests of the child. And so I would like to continue to allow them to do that by supporting the amendment and just removing the exemption so that the screening committee screens these children just as they screen all the children. Madam Speaker.
Thank you, Speaker Terlai. Are there anyone else wishing to speak on the Taitagui amendment? Anyone else? If not, Senator Mary, I will recognize you on the amendment.
Order, Madam Speaker. She already spoke on the amendment earlier.
Then I will ask Senator Mary, do you have a point of information?
No, if it's not been objected to, I just want to raise that point that I object to the bill. To the amendment. Thank you.
Thank you.
So on the amendment for line 13, page 3, there's been an objection. Oh, yes, I'm sorry. A sponsor may close on the amendment.
Madam Speaker, and good morning to my colleagues. And thank you for the opportunity to allow me to close on this amendment, which, Speaker, you spoke on a lot of things that I wanted to bring up. But it doesn't hurt to reiterate those comments. But I want to make sure to let everybody know that I'm not against adoption agencies. I'm not against legitimate adoption agencies, is what I should say. And agencies that have been vetted and regulated. And unfortunately, we haven't established that yet. Again, the cart before the horse. Madam Speaker, it was stated by the author yesterday, and I'm going to quote it verbatim. Quote, "Remember that under this idea, to that the role of the independent adoption agency in the Newborn Infant Safe Haven Act is for there to already have a list of pre-approved families." Unquote. Madam Speaker, unless I missed it somewhere, the Newborn Safe Haven Act, Title 19, Article 5, Section 13501 to 13509, makes no mention of an independent adoption agency, let alone a list of pre-approved families in the Safe Haven Act. There is nothing in there. In fact, what it does mention is when a baby is abandoned under Title 19, Article 5, the newborn, once the baby has been medically examined, will go directly to the custody of CPS. Madam Speaker, in most safe haven, there are 50 states that have the Safe Haven Act, and some territories. But the majority of them all go, the newborn all go to the state. The majority of them. And stay into their custody into CPS. So you see, it's not pure and simple. What this amendment will do is to continue the current process, that's all. Especially now, my colleagues, continue the current process until we can get rules and regulations establishing companies coming into Guam and getting a license just very easily to open an adoption agency. The amendment keeps the same thing in place until that is done. Granted, the adoption screening panel may have reviewed and scrutinized potential parents who wish to adopt. However, the line right before the proposed amendment requests that the ASC must meet as soon as possible for a baby only 1 month old. Now, right before this amendment, the ASC must meet for a child, a baby 1 month or older. That's not far away from a newborn, not far away. But they meet as soon as possible. Madam Speaker, that is really very close to a newborn. And newborns are, as you mentioned, newborns are mostly preferred by adopting parents. And that's why it is too important that the ASC meet as soon as possible, as well to determine the best interest of a newborn. Again, Madam Speaker, there is nothing that was mentioned by the author about independent adoption agencies in the Newborn Infant Safe Haven Act and a pre-existing approval for families. It doesn't mention that in the GAR. I looked, unless I'm missing something, I stand corrected, but I read through it. And GAR only talks about the process of adoption, on how to adopt.
You have a point of, sorry.
I'll yield. No
Senator,
problem. I'll
You have a
yield.
point of, what is your point of information?
May I just make a point of personal preference, point of information, because my words were coded. I just wanted to point out that
A point of information?
a point of personal privilege, the statements that I made yesterday when I used the word idea, the whole point of that is that I was referring to the inclusion of adoption agencies in this bill. If we include adoption agencies in this bill, then there will have been pre-approved families in place.
All right,
My
thank you,
point
Senator.
my point is taken out of context, Madam Speaker, is what I'm trying to point out. And the whole idea is with this whole amendment is that there's nothing that precludes any meeting. There's nothing that precludes it.
Thank you, Senator. You may proceed, Senator Taitakui.
Thank you, Madam Speaker. Once again, Madam Speaker, I'm imploring this body to please consider this amendment. If anything, this amendment, well, at least will continue to provide that one part of scrutiny that's needed to be done. That's all. And like I said, there are no rules and regulations for these private adoption agency companies to follow. So at least let's keep this structure that's already in place. And according to the committee report by Department of Public Health and Social Services, they're already doing the job. And they're doing a great job at it. There are no complaints from them. So please, I ask my colleagues, at least put that safe mechanism in place. Thank you, Madam Speaker.
Thank you, Senator. On the amendment, there's been an objection, so we're going to vote now on the amendment, line 13, page 3. All in favor of the amendment, please raise your hand. Amendment fails. Senator Taitakui, you are recognized.
C2 Masi, Madam Speaker. Madam Speaker, my next amendment is on page 6, line 8. Basically, this amendment, Madam Speaker...
Could you just hold one second?
I'm sorry.
Yeah, please. All right, please proceed.
And thank you, Madam Speaker. Again, colleagues, it's on page 6, line 8. And this basically has the child going directly to the caseworker, which is, public health. And it strikes out, so let me go ahead and read the whole amendment, especially for the listening audience. The amendment, what it does is, it states here the original, what's incorporated, in this legislation. Number 2, the newborn child shall be taken by an adoption agency representative to a pre-approved adoption home or temporary shelter care home until permanent placement occurs. The natural parent's caseworker to previously arrange. Okay, that's all it says, actually. Let me just, because it's important. I've got people who are listening to this who are very interested, so let me do this again, Madam Speaker. Please, I beg your indulgence. Once again, the original law that's been proposed here is stating the newborn child shall be taken by an adoption agency representative to a pre-approved adoption home or temporary shelter care home until permanent placement occurs. And then it strikes out the natural parent's caseworker to a previously arranged foster home if an adopted home has not yet been selected. And that's what's been stricken in the proposed legislation. What my amendment does, Madam Speaker, it strikes out that inclusion where it says an adoption agency representative to a pre-approved adoption home or temporary shelter care home until permanent placement occurs. So I'm striking that out. I'm taking that out and incorporating back to its original, which is the newborn child shall be taken by the natural parent's caseworker to a previously arranged foster home if an adoptive home has not yet been selected. And again, Madam Speaker, it's the argument of, these private adoption companies that are here, or, one is here, we never know after this, maybe more might come. But there are no guidelines or rules or regulations into this at all. So we keep the status quo because it's been working. There's accountability here. So I ask my colleagues to please support this measure. this amendment. Thank you.
On the amendment, is there anyone who'd like to speak on the amendment? Senator Brown, you're recognized on the amendment.
Okay. Thank you very much, Madam Speaker. I rise in support of this amendment, and I think we get down to the basic issue with regards to the custody of a child. You know, I thought about it since we were here yesterday. I thought, gosh, who would I give my most precious, valuable thing that I owned? You know, would it be my diamond ring or my phone? Gosh, because I would wonder, who would I give my phone to and give them custody of my phone? My favorite pickup truck, whatever it is we value in the physical world, who would I give that to? And would I have comfort that they're going to properly take care of it for the time that they have it? You know, as the main sponsor of this amendment has repeatedly said, she's not against the adoption process. I'm not against the adoption process. I think we want to ensure that children in our community have a safe, good, healthy home environment to grow up in, whether they're with their biological parents or their adopted parents that probably care for them more than they do anything else. That's what this comes down to. And putting protective measures in place, I think, is important because I don't know who this adoptive agency is. Right now, the process is through the courts and it's through public health. They're the ones that have the legal authority to address custody of a child. So I called my dear cousin up and talked to her yesterday after we left session to get her feedback and her insight, because she worked for many years in this division, was the head of this division for many years, and up till now still gets called on for her advice and her assistance, even by the very agencies that she's since retired from. And I asked her that question with regards to the custody of children. And right now, legally, that remains with public health. To review even the families, where the families, if there's a family that this child is going to be given to through the legal process that goes through public health and it goes through the court system. No one's arguing the process of wanting to get these children into good homes, but we want to know, who are we giving these children to? All of a sudden, we're giving these children to an adoption agency. Is it Ohala that testified? Is it some other adoption agency that can come into existence tomorrow here on Guam? Because obviously there's nothing preventing anybody from getting into this business. We just go up to Reverend Tax and get a license. The fact that there is no structure. What are the permitting processes and what are the evaluation processes of the government representing the public interest to ensure that this adoption agency is operating in a safe and legal manner? We've seen many examples of abuse in this system, even with adoption agencies. And I think the case in the Marshall Islands, that's within our neighborhood, it's within our region. Maybe some may say, oh, that's an extreme case. That's not going to happen here on Guam. Well, I don't know that. I don't think anyone here in this legislature knows that. But as I mentioned, our desire to do good deeds, the fact that we're not wanting to put these protective measures in place, that we're turning a blind eye to this issue because, we want to pass this bill so we can feel good about it, but we're not putting protective measures in place for these children who cannot protect themselves. We're just going to hand these children over. So does this now change the legal custody of these children from being custody of the government to an adoption agency that we don't even know who they are and we don't know how they're regulated? We're so willing to just do that here without question? Would you do that to your children, your grandchildren? By not ensuring these protective measures are in place, that's exactly what we're doing here in this legislature today with this bill, with the guise that, we're doing such a good thing because we're trying to facilitate these children getting into safe homes, but how do we verify that? Where in the law is the requirements or guidelines or rules and regulations that adoption agencies have to meet on Guam? We're putting them now in the evaluation panel earlier in an amendment or previous amendment. Which member of what adoption agency gets to sit on that panel? Who gets to determine that? But no, we're going to just, act like we're doing such a good deed here. But we're not going to verify and make sure there's a system in place to make sure that these precious children are well taken care of. I don't know the name and face of this adoption agency. Who are they accountable to? Who are they accountable to? The fact that we did not have more deliberation on this bill, which is what that public hearing, my colleagues, which many of you didn't attend or participate in, which is pretty common these days, asked the key representatives that deal with these children in public health, they asked for further dialogue on this issue. The main sponsor mentioned, oh, she talked to Ms. Brennan from DYA. Well, I'd like to have Ms. Brennan publicly make those statements if she's taking a change of position, to be publicly known that she's making those statements, so there's a system of accountability rather than, oh, I had this conversation and this is what she said. Then I find it even more ironic, Madam Speaker. I find it even more ironic that this issue is not dealt with public health, which I believe is under your jurisdiction. You know, we have this interesting way of referring bills in the legislature. Public health that has primary custody of these children through their division, through their child division, they raise these concerns and we turn a blind eye to it.
Point of
think that's
personal privilege,
something-
Madam Speaker. I just want to state for the record that we
Do you have
do
a point
have
of
in the committee...
information or a point of order?
A point of order, Madam Speaker.
Please state your point of order and your citation.
Point of order is we have on the record in the committee report an official letter written by Melanie W. Brennan, Department of Youth Affairs, who we know has been assigned oversight of CPS by the governor through executive order. Her letter dated May 17th, 2021, on the record
you.
stating
Yeah.
her position.
Is there, all right, thank you. Please proceed, Senator Brown.
Nevertheless, Madam Speaker, while this recent executive order has come into place, public health primarily has had primary responsibility of dealing with child welfare on Guam unless they've been removed. I'm not aware that they've been removed. Those that have been experienced and have worked with these issues for many years have raised concern about this. They raised concern publicly during the public hearing, asking for more dialogue. I believe there should have been more dialogue with regards to this issue so that we can get a clearer picture. And it didn't happen. We rush here now in session as we trip over ourselves to make sure we get bills on the agenda without properly vetting these issues so that these questions can be answered. Because we are allowed to raise these questions. I mean, I'm not here to paint a pretty little picture to make everything look so good. When these are legitimate concerns, my dear colleagues, we're dealing with children that cannot protect themselves. And so we have a responsibility to ensure that who we are handing these children over to, even if it is an interim process, that there's a process to vet these adoption agencies, or agency, whatever the case may be, that there are standards and rules and regulations these adoption agencies should be able to meet. We've never, to my knowledge, had an adoption agency on Guam. And I don't think it's a bad thing that we have one, but I want to know what's regulating an adoption agency. What standards do they need to meet? What requirements do they need to meet? Now, while it's said, oh, we have a nonprofit organization, well, that's nice. But what's involved in the transaction of these children? I mean, do they hire people? Obviously, they have to compensate people unless they're all just doing it full-time voluntary, or maybe there's only a few children a year that are going to go through this process. But I don't know that. I don't know that. Do any of you here in this legislative session hall know the answers to that? If you do, please stand up and say and let us know, let the public know what those standards are. I can't believe we are moving forward with these type of questions being raised. Is it because I'm raising it? It's because Senator Tello's raising it? We're not in the crowd here we're not in the in crowd. I think we need to get past that kind of nonsense because these are real issues that are affecting children in our community. Children, unfortunately, in our community that don't have homes for whatever reason, that their parents are unable to provide that safety and security and positive environment that we'd love to see all our children have. But to proceed with this without addressing some very fundamental concerns and simply handing over these children to who we don't know who we're handing them over to. We just have the word adoption agency. Who are these people? oh yes, let's stick and look at our phones and our computers and, let's let it pass. Well, then if you let it pass on your own conscience. But I support this amendment. I think anything we can do to ensure, we talk about transparency in our government, for goodness sakes, with how we're spending money. But when we're also talking about transparency, of how do we ensure accountability of these children that can't protect themselves? But we're just going to let it go, right? We'll just let it go and ignore the issue and move on to the next bill so we can say, we got a bill. Look, people of Guam, look at me. I really think we need to look at the real fundamental issues here. And I don't know why there's such resistance to ensuring where is the rules and regulations? Where are the requirements of what an adoption agency needs to meet? Where are those things? Please come forth, stand up, and tell me where it is in the statute so that we can ensure there's some process of procedure.
Madam Speaker, if I may.
Do you have a point of order?
On a point of order, and I'm just getting the documentation down. The
Do you have
senator
a
from
point of order,
Chalampago,
Senator?
hold on. Madam
No,
Speaker.
do you rise to a point of order?
Yes, I find a point of order or a point of information in reference to the adoption agency that would be included that has a public-private partnership and has had committees down. I'm asking my office to bring down these brochures to
All right.
talk about the
Please,
adoption agencies,
You
Madam.
can raise those points
And-
during your debate on the amendment, Madam Senator.
But Madam Speaker,
Please.
I'm
We are
answering
debating
an
the amendment.
inquiry based on her asking the question to this august body about, do we know anything about this
She has not asked that
nonprofit?
anyone yield. Please, you can raise that information during your debate on the amendment. We are not supposed to use our points of order or points of information to interrupt debate on the
Madam
measures.
Speaker, if I
So
may,
we are
with all due
debating
respect,
an amendment.
they are talking about an organization that has gone through, that literally has gone through the process of being a certified agency, a nonprofit organization here on Guam, and we as an August body have that information, and it has been given to this
All right,
August
so
body.
please
So
provide
for the
that
record,
during
I'm
your-
asking
your
that
debate on the measure.
that you give me the opportunity to just bring that information to show our colleagues.
You have that opportunity. Will be given an opportunity also to debate on the measure and to bring up
Madam-
any information you want. So out of order, please. Let's proceed. Allow the person who is debating the measure to proceed with their debate without interruption.
Thank you very much, Madam Speaker. I never realized how difficult it was to speak at a public hearing or speak on the floor of the legislature without being interjected and cut off. Seems to be common habit these days here. I guess I'm old school. Again, I'm going to bring that up, colleagues, in your conscience to seriously think about this. Don't ignore the issue. Perhaps this one particular adoption agency has gone through and they're saying, oh, we support it. But in the government, in the law, what are the requirements? What are the requirements that an adoption agency needs to meet? What are the rules and regulations that oversee any adoption agency that may want to set up business on Guam? Where are they? Where are these government procedures to determine how the government of Guam, through their respective agents, vet an adoption agency? What are the reporting requirements? That's what I want to know. Not whether they're, a certified nonprofit. I can go set up a certified nonprofit. I think those are critical issues because we are stepping out of what the existing structure is. That may be a good thing. I don't know. I don't know that until I know there's some safety measure in law in place to address the custody and the safe custody of these children. And I can't make a single adoption agency be the reference point. I think it has to be a standard that any adoption agency, because there's nothing to prohibit anyone else from setting up shop. Maybe this one's a nonprofit. What if the next one is for profit? I think those are all good, legitimate questions because at the end of the day, Madam Speaker, what is motivating people? There are many good people out there that want to help these children, and of course, this can be a conduit to help facilitate that. But I don't want this to be a conduit to facilitate from children being a bad situation to another bad situation. Because we don't have safety measures in place to ensure that there's accountability in this process. That's what I want to see. If that was there, if that can be provided, then I would be happy to support this bill, because I think if we can get a system in place to assist the government, I see that as a good thing. Because we know there are many children out there that don't have those opportunities right now. Children that are in the foster care system that don't, because a lot of people, what do they have to think of? Gosh, can I support another child? Do I have the resources, the time, the effort, the energy? Could I take care of other children? When we were growing up, for the most part, it was easy because families absorbed their children. Maybe there was a favorite aunt that didn't have kids, or her kids were grown and she could take care of other children. We all had that favorite aunt. When our parents were at work working, who would take care of us? Or grandparent. And a lot of young people now, children don't have that. They don't have the same family structure. So obviously we have to change, we have to adapt so that we can help facilitate. Because we don't want to see any of our children left behind. But I also want to make sure, Madam Speaker, as a member of the legislature here, as a policymaker in a position to address policy on behalf of our people, that those safety measures are in place. And if they are, then good, we can all move on. But I can't simply make, oh, this is the particular agency, and they're all good, and I'm sure they probably are. But I think we want to make sure that they are, and anyone else who chooses to get into this area, that they also have to meet these review requirements. And I want to know whether or not, and I wish we could further dialogue on this so that we can ask the key employees and the division that works on these issues, do they have the resources to do that? To go and do these follow-up inspections to ensure that this is a proper process. I don't think there's anything wrong. As a matter of fact, we should be demanding that. That should be the standard, not the exception to this process. So, Madam Speaker, I rise hopefully without any further objection of supporting this amendment, and I hope my colleagues will seriously consider what they're doing here. Because as I asked you, what is your most valuable thing that you have in this physical world? And who would you hand that over to? Who would you give responsibility of that? Would you do it for an hour? Would you do it for a day? Would you do it for a lifetime and feel some sense of comfort? When we have no definite awareness of the process that who you're handing this over to is properly being regulated and reviewed. Because, Madam Speaker, let's not kid ourselves. We've seen where abuses have happened in this area. We don't have to look very far. And let's be mindful of that. Let's be mindful to ensure we're being responsible with what we're doing when we make decisions on behalf of our people, more importantly, on behalf of our children. Thank you very much, Madam Speaker, for the opportunity to comment on this amendment.
Thank you, Senator. On the amendment, Senator Torres, on the amendment, you're recognized.
Thank you, Madam Speaker. It should be noted that in this bill under Section 1308, subsection H, it's true, and it was stated, social services has to contact the adoption agency first to notify them to take guardianship of the baby. If you weren't the agency contacted, you don't get the baby. Secondly, I want to point out that it's true. I want to reiterate. Social services then maintains legal custody of the baby until the termination of parental rights, which has to be approved by the court. Social services is always in control. So that if an adoption agency, which, let's remember please, is selected and contacted by social services. The adoption agency is selected and contacted by social services. These people can't decide to run off with a baby instead of taking it to a pre-approved home. If we're talking about illicit activity, you can bet your last dime that if any agent, whether it's an attorney, a doctor, a relative, acting on behalf of facilitating an adoption, if they were to do anything that is in violation of the laws of Guam that deal with adoption, the policies and procedures, Title 19, Chapter 4, Article 2, Title 19, Chapter 13, Title 19, Chapter 4, Article 3 and 13, 3 and 4, 26 GAR, Guam Administrative Rules, Article 3. any of these, anyone who dares to do harm to the child in violation of any of the policies and laws in Guam statute and our administrative rules will no doubt have public health, the courts of Guam, the Guam Police Department on them. I just want to refer you back to subsection H1 on page 5. And it's true. It's absolutely true. Social services maintains custody of these children. There's a difference between guardianship and custody, Madam Speaker. But most especially, I don't want to go on hypotheticals. I want to just bring us back to specifically what is in law and the fact that the overview and the enforcement of adoptions plays always, absolutely, with social services maintaining full custody until parental rights are relinquished by the courts and adoptions are verified by the courts of Guam. So I rise in opposition to this amendment, and I only want to cite to what is specifically Guam laws and rules and who the authorities are and how they are never out of the equation for any adoption agency selection or placement of a child with an adoption agency for placement in a home. You can never bypass that without being in violation of the law and accountable to the law and punishments for violation. So please, let's just focus on what exactly the law states and oppose this bill, oppose this amendment to the bill.
Thank you, Senator. On the amendment, is there anyone else who'd like to be recognized on the amendment? If not, then there's been an objection, or sponsor may close on the amendment.
Situs Masi, Madam Speaker, and I thank you, my colleagues, for bringing up concerns. You know, it even just justifies the whole purpose of what we're doing here today. You know, and that's about accountability and transparency and providing most especially the safety of our children. Nobody's debating the fact that an adoption agency may be needed on Guam. I've been trying to get the numbers from public health. How many women have taken advantage of the safe haven? How many adoptions have there been on Guam? Is there just this influx of babies that there is such a rush to it that public health cannot do their job? Are they overwhelmed in that circumstances? During the public hearing, they said no such thing. Madam Speaker, the problem is that there are no laws here to guide a private company, adoption company. There are no guidelines. There are no structures, rules, regulations at all. You know, I don't personally know Mrs. Boss, or, you know, I only read an article about her, and I can't even review what tests that she said she has taken or any background checks that she has done or her staff has done, which should be publicly transparent for everyone to see. You know, and based on how these amendments are going, who's gonna really lose here? There's a few of us in here fighting for these children, the safety of these children, and not turn Guam into an area where people can come and make it easier for human trafficking. Madam Speaker, just put the process still in place right now. until we can come up with these rules and regulations to make it safe. It's not just Ms. Brennan that oversees this. It's public health. It's public health that does most of this work, the social workers. Which is ironic, Madam Speaker, because why is this legislation in a different committee other than Health Committee? There's the red flag in the first place. This bill should have been heard in the Committee on Health and Public Health. So, Madam Speaker, we have an opportunity right now to work together to make it right. So let's do that. Let the people of Guam see how much you care and are concerned. And humbly ask for your support in this measure. Thank you, Madam Speaker.
Thank you, Senator. On the amendment on line 8, page 6, there's been an objection. We'll now vote on the amendment. All in favor of the amendment, please raise your hand. Amendment fails. Senator Taitukui, you are recognized on the bill.
Thank you, Madam Speaker. Madam Speaker, I do have one more amendment. However, while it's coming on to the on our folder, our doc folder, I'd just like to say a few words, and once it's introduced, I'll be very short. And I really appreciate my colleagues for their indulgence in allowing me to try and fight for what I think is really, really important here, our children. Madam Speaker, I do have a question, though, to the author of the legislation.
Please state your question.
Thank you, Madam Speaker. So my question is, what does it mean to be duly licensed under Guam law for an adoption agency?
The author yield to the question.
Madam Speaker, I'd like a moment to be able to answer that question. We know that duly licensed means in conformance with Guam law that would require them to get a business license with Department of Revenue and Taxation. However, we also are aware that adoption agencies also filed under a nonprofit organization under 501c3, has articles of organization and bylaws that very clearly outline their operations, their processes and procedures within their articles and bylaws. And those also are in conformance with all the regulations that I alluded to previously. Guam regulations and Guam statutes, for example, the adoption statutes in Title 19, Chapter 4, the Child Protection Act in Title 19, Chapter 13, the child welfare issues in Title 19, Chapters 4, and also 26 Guam Administrative Rules, Article 3. So they are all in compliance with that, in addition to having all the background checks and clearances that they are required to get in order to operate as an adoption agent. And remember, this adoption agency is a 501c3 nonprofit organization duly licensed under the laws of Guam. But again, where the guidelines come down is in their specific articles and bylaws that are very specific to adherence to Guam laws with regard to Adoption and Child Protection Act, Child Welfare Acts, and the administrative rules and regulations that deal with adoption procedures on Guam. So I hope that sufficiently, I'm not an attorney, but I understand in speaking to attorneys that is the process by which one becomes an adoption agency, duly licensed under Guam.
Senator Teichberg.
And thank you, Madam Speaker. So from what I gather, there really is no laws other than a nonprofit organization, which, okay, everyone knows that there's rules and regulations for a nonprofit organization regarding funding and how it can be spent. Background checks, I didn't see anything in Guam law that requires background checks. Well, technically, there are no laws on Guam to open up. And that's my question. My question was, what does it mean to be duly licensed under Guam law? But I didn't hear anything that said where the Guam law is. So I can only assume there isn't any. So I have another question, Madam Speaker. Is there anywhere, if I may, Madam Speaker, I have another question to the author of the legislation, if I may.
Please state your question.
Thank you, Madam Speaker. So my question is there anywhere in the proposed legislation that provides guidelines, standards, and regulations on adoption agencies first before surrendering any of our children to a private adoption agency?
The sponsor yield to the question.
Madam Speaker, as I have mentioned before, an adoption agency, as contemplated in this Bill 108, is an agency that is duly licensed under Guam law and that is selected, recognized by Department of Public Health and Social Services. So if you have to go back to what I've been trying to emphasize, the oversight and control of any issues that deal with Child Protective Act fall under the purview of Department of Public Health and Social Services, Child Protective Services. The oversight is always over them. And so the question was, where in the law does it do that? I just want to point out that we put in to the bill, just to be clear, an amendment that would require an audit. That's not to say that that doesn't already exist as their prerogative in their oversight and enforcement capability. So it all goes back to the conformance with the laws. The laws are spelt out, what the laws are governing Child Protective Act and adoptions on Guam and the policies. It's all laid out. And it's up to public health to determine whether an adoption agency is suitable to be an agency that they work with or not. An adoption agency could be anything. And adoptions occur all the time on Guam. They occur with agents that are attorneys. They occur with relatives who go between themselves. So bottom line is the laws are in place, public health has oversight, and that's what it is. Is there a specific law to how to set up an adoption agency? Not yet, but that's not to say that they're not set up lawfully and that they don't conform to all the Guam laws that deal with child safety and adoption procedures.
Thank you, Senator. Senator Teichberg.
Madam Speaker, and thank you for answering the question, but I don't think it was answered because we're not talking about the process of adoption that's currently ongoing now. What's required of the adoptive parents, which is done through Department of Public Health and Social Service. They provide that scrutiny. They do the reviews. The ASC does reviews as well. But we saw that because now we have an adoption agent, a private adoption agency sitting on the ASU, which is a total conflict of interest. Madam Speaker, the question was not answered. Is there anywhere in the proposed legislation that provides guidelines, standards, and regulation on adoption agencies first? Before our government of Guam surrendering any of our children to the private adoption agencies, it's not answered. So, Madam Speaker, the laws are in place for the process of going through an adoption, which can be done by an attorney on Guam, with the collaboration of public health and social services, caseworkers. But there's nothing for the accountability of the agent, the private adoption company itself, other than they put their own bylaws together. Like any nonprofit organization, they have their bylaws. They can make whatever they want in their bylaws. So, Madam Speaker, I have another amendment, and if you give me one minute, I'd like to, and I promise it. Thank you, colleagues. This is my last amendment. If you can indulge me with this, I just have to get a copy of it in front of me. Thank you, Madam
All
Speaker.
right, 1 minute recess. We're back in session. Senator Taitakui, you have the floor.
Thank you, Madam Speaker, and thank you for that break. We're still working on the amendments that I'd like to, I said one amendment, but Madam Speaker, as you're speaking to legal, it's going to have to be a two-prong approach on the amendments. But before I do that, Madam Speaker, it was brought to my attention that we received a letter from Public Health, and I ask if one of my colleagues can please read the letter into the record, Madam Speaker, and I call upon Senator Joanne Brown if she can read that into the record. Greatly appreciate
Senator
it.
Brown, would you yield to that, to the reading of the letter?
Thank you very much, Madam Speaker. I'll do my best. It's quite a long letter, but I will do my best to read it. Buenas and Hafa Senator Torres. I want to thank you for the opportunity to speak on behalf of Bill number 108-36 and 109-36. As a foster parent, I share a vision that Guam's children will live long and healthy lives in loving and caring homes. As a foster parent, I know that no two children's journey into adulthood is alike, and that my many years with DPHSS Child Protective Services has shown me a world that very few people know exists, or to what extreme. It is for this reason that I join you in moving cautiously when it comes to our island's most precious resource. The testimony regarding Bill number 108-36 and 109-36 was energized with emotion and concern, and it should have been by the sheer nature of the subject. There is a lot that is unknown and much that needs to be discussed in detail. I've had the good fortune to oversee Project Carinu, Guam's early childhood mental health program, addressing social, emotional, and behavioral well-being of children newborn to 5 years of age. I understand the need and value in placing an infant, all children for that matter, in nurturing and loving homes, especially during the early development of an infant's life. I agree that the placement of a newborn with their prospective adoptive parents needs to take place soon after birth. However, experience has taught me that teens and young adults are not immune to changing their minds, and even more so regarding the termination of their parental rights. It has not been the practice to place infants available for adoption in foster homes for this very reason. However, it has been a safety net when the natural parents of an infant change their mind about giving up their child for adoption. It is incredibly painful for the adoptive parents to have this wonderful family addition removed once in the home. While there are many horror stories of foster parents that have abused and or neglected their foster child nationally, locally, this is a very rare event. BOSA has foster parents that have loved and housed children for many years, developing a bond that has transitioned a foster child into a healthy and productive adult. We have foster children now grown that continue to live with their foster parents, sharing a strong familial relationship. The practice of hiding a pregnancy still exists for some young adults and women for reasons such as substance abuse and communicable diseases. Although perfect in the eyes of God, the possibility of neurological damage or immunodeficiency is highlighted with this diagnosis, and the impact to the child may not be known for months or even years after birth. Hiding a pregnancy often results in a lack of prenatal care that would otherwise address these concerns early on. BOSA's current practice of placing infants and children into foster homes prior to their adoptive homes allows time needed to identify a committed adopted family willing to take a child with special health care needs or one that tests positive for substance exposure at birth. Although few, BOSA has had a history of these cases and the outcomes have been favorable in that the foster parent, not seeking the perfect healthy child, but willing to provide unconditional love, adopts the child. At the time Bill number 108-36 and 109-36 was in public hearing, 432 children were in foster care to include licensed foster homes, 78, group homes 22, treatment facilities 6, parents with physical custody 53, a relative 221, A non-relative placement, 52. This record number of children in foster care is reflective of the social changes brought on by substance abuse, babies testing positive for drug exposure, homelessness, issues of mental health, unemployment, and substance abuse, domestic violence, often triggered by financial hardship and lack of coping skills, and teen pregnancy, sexual assault. Of the 432 children in foster care, 0 infants were available for adoption. BOSS used to conduct home studies on every family that completed an application for adoption. Because of the lack of infants and children available on Guam, annual studies were discontinued. However, adoption applications and annual phone calls updating adoption applications became the practice. If an infant or child was available for adoption, then applicants with identifiers that match the child were contacted and a full home study was conducted. Many of these applicants were military families and often transparent in that they had difficulty in adopting in the U.S. mainland due to their limited tour. Further, the placement of an infant or child needed to take place early on in order to cover the required monitoring period as required by the country or state they lived in. This is no longer the case for many military families, as the Interstate Compact on the placement of children provides protection and support to the child while the prospective adoption parents complete the adoption placement period. Guam is not a member of the ICPC. Looking over Bill number 108-36, there are recommendations I offer that include Section 1, Section 1302, intent of the law, page 2, line 7, or an adoption agency duly licensed under Guam law. In reference to the duly licensed under Guam law, is this pertaining to an agency's business license, nonprofit, for-profit status provided by the Guam Department of Revenue and Taxation? Or is this referencing a process that needs to be developed which will license private adoption agencies in order to regulate? I'm not aware of existing rules and regulations for adoption agencies to be licensed on Guam. Section 1, Section 1302, intent of the law, page 2, line 11. And that the child live in the adoptive home for a period of up to 1 year. Question: the monitoring period is a tool that an experienced adoption custody worker will use as a safeguard the placement of a child in their new adoptive home. This time is used to assess the child's attachment to the adopted family and to observe if the child is bonding to their new environment. It is also a time to assess if a child's needs are being met and to address concerns or issues about the adoptive placement. Page 2, line 11 provides a maximum timeline, but fails to provide a minimum timeline for the monitoring of the placement. In my experience working in BOSS's adoption and custody unit, HALT International requires a 4-year monitoring period for the placement of a child in a prospective adoptive home. Guam only requires a period of 1 year in comparison. I recommend we maintain the current provision of a 1-year monitoring period and no less. Section 2, Section 1308, selection of adoptive parents, adoption screening committee. B, composition of committee, page 3, line 1. A representative from an independent adoption agency. Question: if the adoption agency is doing business on Guam, how are they independent, private versus public? In the interest of the process to ensure objectivity is maintained throughout the process, I do not recommend a representative from a private adoption agency serve on the ASC, as this would appear to be a conflict of competing interest. Section 2, 1308, selection of an adoptive parents adoption screening committee. C, chairman of the committee, page 3, line 9. An infant relinquished under the Newborn Infant Safe Haven Act pursuant to Article 5, Chapter 13 of Title 19, Guam Code Annotated, will not require meeting under the ASC. Question: what is the intent of taking the adoption selection committee out of the adoption process? I recommend the current practice be maintained by which the Bureau of Social Services Administration is the lead agency responsible for the newborn. Section 2, Section 1308H, procedures involving an adoptive child, page 5, line 26. The newborn child shall be taken by an adoption agency representative to a pre-approved adoption home or temporary shelter care home until permanent placement occurs. Question: who will regulate the temporary shelter care home while waiting for the permanent placement to occur? How is this different from the process currently in place utilizing licensed foster homes? Therefore, I recommend that the process remain as it currently is. Again, BASA remains the lead agency in the assessment and placement in the adoption process. As I work on this document, I'm reminding of the 10th anniversary of the 2 young girls from Saipan that went missing. To date, have never been found. I am reminded of the baby selling scheme that took place in the Marshall Islands, targeting the poor and vulnerable. I'm not saying that Bill 108-36 and 109-36 will lead to tragedy and hardship. However, I am expressing the need to move forward cautiously and to question in-depth and long-term impact that these 2 bills will have on the Guam adoption process. Therefore, we remain available to discuss bills further to address the recommendations and concerns contained herein. Once more, thank you for allowing the opportunity to express my recommendations and concerns. Terry G. Uggan, Deputy Director, Department of Public Health and Social Services.
Thank you for yielding. Senator Taitakui, you still have the floor.
Madam Speaker. Madam Speaker, I believe there's a recommendation to recess and come back at 2 o'clock.
Is there any objection? There are no objection. We will stand in recess until 2 p.m.